right, so we ended the last meeting on page 61 at appointment. And then page 61, it says towards the top, it says the governor appoints an individual to the office of notary public in and for a particular parish after the applicant meets all the requirements of law on the appointment. For all applicants, attorney and non-attorney, appointment as a notary public is for the parish of residence unless the commission is a paid commission. And it says the appointment process involves all three branches of government. And the first one is the executive. The Secretary of State oversees the application and qualifying process for persons who seek appointment as notaries public. Once it is determined that an applicant holds the necessary qualifications and has met all the conditions for appointment, the governor may appoint the applicant to the office. The governor submits the names of notaries appointed to the office for the Senate advice and consent. The Secretary of State issues a commission to the evidence of the appointment, which is an interim appointment until the Senate acts upon the appointment. And I think these three things are certainly testable material, you know, and they're going to be in a multiple choice format. They're not likely to ask you to recite all of the authorities of the executive, but knowing the executive, judicial, and legislative is going to be critical. All right, so the second part of the appointment is judicial. If during the application process there arises the question of good moral character, integrity, or sober habits, the application is submitted to the court in the parish of the applicant's residence for judicial review and approval. If the judge finds the applicant competent and possesses the character and fitness to serve as a notary public, he issues a certificate to that effect to the Secretary of State. And the third, yes ma'am?
How would they know that?
That you're sober?
No, how would they know? What do they do? I mean, what do they do to verify?
You probably get an affidavit from, I've never actually seen this part in motion, but you probably get an affidavit as to good moral character signed by someone else in the community, something to that effect. Is that what you're referring to?
Yeah, just want how they verify something.
You know,
like
you
that.
typically would just take an affidavit from someone else that says, I've known her for a long time, she's a good person, goes to church, you know, that kind of stuff.
Okay.
It's always by a preponderance of the evidence in these kinds of situations.
Okay.
And there's nobody, assuming there's nobody there saying, she's a bad lady.
Yeah,
you know,
I'm just curious.
Right. Yeah, I think that you're given the benefit of the doubt.
Okay.
Legislative, the Senate must consent to and confirm the appointment by the end of the first regular legislative session following the appointment, or in the event the appointment is made during a session, by the end of that session or the appointment terminates. Qualifications. To qualify for the appointment, the applicant must be, and these are important, they must be a resident of the state of Louisiana. Because there was a question someone posed last time. They moved to Mississippi, but they want to be a Louisiana notary. Boom, doesn't work. To qualify for the appointment, you must be a resident of the state of Louisiana. Be at least 18 years old. Be able to read, write, speak, and be sufficiently knowledgeable of the English language. Have a high school diploma or equivalent. Not be under interdiction or incapable of serving because of mental infirmity. Not have been convicted of a felony for which he has not been pardoned. What if you're 16 years old and you've been oh my goodness, emancipated? We're 16 years old and emancipated. Does that work?
No.
You sure?
Oh,
No, it doesn't work because you've got to be at least 18 years old. That's the rule. What's that?
Don't you gotta be registered to vote too?
Got to be registered to vote. If you're a citizen, you must be registered to vote. So, you know, what happens is I don't want you to kind of get into the trick bag where you start rationalizing why it could be something else. If the book is kind enough to give you the answers, boom, 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 those are the answers. Okay? And don't rationalize yourself out of the obvious answers. Procedures for, okay, and so I didn't read that part. Additionally, this is after the last bullet point, it says, additionally, if the applicant is a citizen, he must be registered to vote in the parish of his residence. All right, so here are the procedures for appointment. A person who possesses the qualifications for office listed above may apply for appointment as a notary public by doing the following. 1, submit an application to qualify for appointment to the Secretary of State on a form furnished by the Secretary. All applicants, including attorneys, must file an application for appointment. Take and pass a written examination administered by the Secretary of State. The following, however, are exempt from the examination requirements under revised statute 35191C2C or revised statute 35191E. So these are the people who are exempt from having to take the test. Attorneys who are licensed to practice law in this state. Currently commissioned notaries who are obtaining a dual commission. Notaries who are changing residence to another parish who have taken and passed the state notary exam on or after June 13, 2005. Notaries who are changing their residence to another parish and have held commission for more than 5 years. Anything about that list seem worth talking about? I think it's all pretty straightforward. This is the third thing you need to do. So under the procedures for employment, there are 3 things you must do. The third thing is you must give bond in favor of the governor in the amount of $10,000 or maintain errors and omissions liability insurance of at least that amount unless exempted from requirement to post bond. And so you often hear errors and omissions insurance referred to as E&O. So when someone talks about their E&O, they're referring to their errors and omissions. I use the term E&O, and that's what it stands for. So if they have a bond, how much does the bond have to be?
$10,000.
And if they have E&O insurance, what's the minimum policy?
$10,000.
Can it be more?
Yes.
Sure.
Is there a reason why it should be more?
Yes.
What do you think, Rebecca? Why would you have more insurance than that?
Well, it depends on how confident you are in your abilities.
Okay. Well, one of the things that we talk about is the fact that we're not limited to liability of $10,000 in our capacity as a notary. We can make more than a $10,000 mistake. And so sometimes people have a tendency to get comfortable with the idea that they need a $10,000 bond. I'm good. The reality is that $10,000 bond, in an event you create a $20,000 problem, will pay out $10,000. And the person who's incurred the damage from that error is going to have the opportunity to proceed against you for the balance of what they're owed personally. So it's always a good idea, I think, to have more than the minimum amount of coverage. Now, I don't know what night we do this, but we actually bring in an insurance agent.
Yeah.
It was a little bit later towards the end of the program. We'll actually bring in an insurance agent who will talk to you about the differences between bonds and insurance, the differences in the cost and the differences in the procedure. What do you have? You have E&O?
I have E&O.
You have E&O. And I think, now I'm not selling you guys on anything, but I think what you determined was that the cost of the E&O was a little bit cheaper and you got more coverage. Is that right?
Twice the coverage for less money.
Twice the coverage for less money. All right, so, but we'll actually bring in someone who will be an expert on bonds and insurance. We'll talk to you about the inner workings, but in a more practical manner, in terms of how this would benefit you or how you would utilize this to bring that person in. It says any applicant who is not an attorney, this is in the bonds or insurance section on page 62, any applicant who is not an attorney licensed to practice law in this state is required to furnish and maintain either a surety bond in the amount of $10,000 or maintain errors and omissions insurance in the amount of at least $10,000. Bonds, generally, a bond is a guarantee of financial responsibility in connection with the performance of an obligation. Rather than depositing cash as the guarantee, the bond is usually given by a contract of suretyship or special mortgage. And so, is anybody in here familiar with bonds? Anybody in here work with bonds? We had an insurance agent with 2 groups ago. She was very familiar with the bond process, but is anybody else in here familiar with bonds? No? No? All right. So a bond typically is, $10,000. Not everybody wants to take $10,000 of their checking account and deposit it somewhere. So a bond is a type of an insurance product where you have your financial condition examined, an insurance agent determines that you're capable of satisfying the $10,000 bond if called upon to do so. They'll collateralize that bond possibly with some equity in your home, and that bond will serve in place of the policy. And so I'm not sure why a person would lean towards a bond over another situation. Maybe somebody just has a tremendous amount of equity in their house, and for them it's just easy to pledge $10,000 of equity in their home towards their bond. But a bond is a type of insurance product. You get them from an insurance company. And it says, so, top of page 63, after that first sentence, it says, indeed, by signing the bond, the surety tells all who may need the services of a notary, you can go with security to this notary. I assure that he is a competent officer, that he will and faithfully discharge and perform all the duties imposed upon him by law, and if he fails in doing so, I'll be responsible to you for the loss sustained. So the bondsman, okay, and you might be more familiar with like getting bonded out of jail, where a person comes in and puts up a bond and the judge releases you as a result of that bond, and there's an expectation you will perform, and you'll come back before the judge, you'll come back to court and address whatever you've been charged with. So this bond that is being issued is essentially the same thing. This bond says, Sanjanita is a good person, she's a good notary, I stand behind her to the tune of $10,000. You can come to her in good faith that she'll perform her duties faithfully and prudently in her capacity as a notary public. Okay? It says, if therefore a person calls on a notary for the performance of a duty incumbent upon him and the notary fails therein, an injury is suffered, the surety is liable to the party injured. Now what they're not saying is that if a person comes to you, you have to do some notary work for them. What they're saying is that they come to you and you do some notary work for them, and you're negligent in the processing of that work, and an injury is occurred, then the person who provided the surety, the person who provided the bond, is going to be liable to the third party who was injured as a result. not every mistake you make is going to cause a third-party injury. Okay, so there has to be a damage. It's not like, hey, I made a mistake, you gotta write me a check. That's not the way it works. I made a mistake, that mistake caused you a damage or an injury, now we gotta talk about how we're gonna make this right. General statutes covering bonds for public officers are found in revised statute Title 42, 181 et sequence. Number 181 says a bond with surety residing in parish or by a surety company. All public officers who are required by law to give bonds shall give bonds secured by a personal surety residing within the parish where the officer exercises the functions of his office, or by a reputable and reliable surety company doing business in the state. 183 says the bond of the state officers shall be made payable to the governor and those of the parish officers to the president of the police jury or other governing authority of the parish. And 198 says a special mortgage may be substituted for a bond appraisal. All public officers commissioned by the governor who are required to give bond may give a special mortgage on property situated within the parish in which they respectively exercise their functions. The mortgage shall be accepted by the person appointed by law to accept the bond. So if I've got a house in St. Tammany Parish where I'm commissioned and where I reside and where I'm registered to vote, and I've got a tremendous amount of equity in that house, or just enough to satisfy the bond requirement, I can offer the equity in my home as a special type of bond in lieu of the bond insurance products that we talked about prior to, or the E&O insurance we talked about prior. It says the public officer proposing to mortgage property shall exhibit his title and a certificate of mortgage to the persons authorized to approve the bond. He shall cause the property to be appraised and not receive it unless it is double the amount of security required after deducting all mortgages. So if I've got to put up a $10,000 bond and have a $100,000 house, what's the maximum amount my first mortgage can be for me to still qualify underneath this particular term? Basically, it's $80,000. That's right, Lorraine, $80,000. So that's what happens. So it's got to be double. So it says after deducting all mortgages. So I've got a house worth $100,000 and it's being appraised in this process. So someone's going out and confirming it's worth $100,000. So after it's been determined worth $100,000, I have to have twice as much equity in the house as I need. I need a $10,000 bond. I got to have at least $20,000 in equity to get that $10,000 bond. My first mortgage can't be more than $80,000 for this to work. Y'all see the math? Okay. Release of sureties by special mortgage. All public officers who have personal sureties in their official bonds may at any time release them by giving a special mortgage as provided by revised statute 42-198. So if I have personally guaranteed my surety bond, if I personally guaranteed it, that was the nature of my relationship with the insurance company that issued the bond, and you're almost in every instance when you're not pledging property going to have to personally guarantee it. If I need to get my personal guarantee off for some reason, then I can go back and offer the property in lieu of. So typically what they're saying is in this bond, either you're putting your signature on the dotted line or you're putting your property on the dotted line, one of the two.
Seems risky to do that with your mortgage.
Seems risky?
Yes.
Why do you think that?
Because if something happens, then you lose all that equity in your house.
But you would lose
your house.
You would lose. Well, okay. You lose the $10,000.
Yeah.
That's what you're going to lose because that's all that you pledged is the $10,000. If you've created a $20,000 problem, certainly the person that has been injured by that has the right to go after the balance of the $10,000 in equity that's left over. Would you lose your house? Yeah, there's a good chance you lose your house, but it's not necessarily very practical that you'd lose your house in the example I just gave.
Right.
Because in order to come and take $10,000 out of equity in your home that's got an $80,000 mortgage in front of it, I got to be prepared to write a check for $80,000 to pay off your reverse mortgage holder to get it. Right. You know, that's the reason why they want to double the amount, is because foreclosing on a home to go get that equity costs money. And so if I have a $10,000 equity position for a $10,000 bond, I can't realistically recover $10,000 in a foreclosure situation because it's going to cost me $5,000 at least to get there, which means I can only really net $5,000. So they're looking for double the amount to make sure there's enough to justify the effort and the cost it takes to recover the property. And I'm not suggesting that you're not 100% accurate when you say it's risky, but you're going to be liable in some capacity for an injurious document or for injuring a third party as part of your notarial duties if you do something negligent. So whether it's your home or it's a personal guarantee on a bond that allows them to go after your home contractually after they've got a judgment, I mean, if you make a mistake, your personal assets are at risk, which is why I like E&O. Because we've determined that You can get more than $10,000 worth of coverage for less money by paying the premium on the E&O. So I don't think you can ever be overinsured when it comes to liability. I don't think you can ever be overinsured. All right, operation of bond as a mortgage on the bottom of page 63. The notary's bond does not automatically operate as a mortgage against the notary or the surety's property and must not be included on a mortgage certificate until the notary has been sued and a notice of that litigation, which is called a notice of lis pendens, has been filed in the mortgage records. So what they're saying is that if you have a surety bond that is backed by, you have a bond that's backed by property, a property bond, and a mortgage certificate is run. We talked about mortgage certificates, we may have just briefly touched on it, but a mortgage certificate is something that's generated by the clerk of court, and it will tell a third party all encumbrances against the property run and all encumbrances against the individual owners of the property, so a person can make a quick assessment as to exactly who owes what and who owns what. That mortgage certificate will be there. We'll show you that. But the property bond that you post in conjunction with being a notary isn't going to be in that mortgage certificate. It's not going to be there because it doesn't technically serve as an encumbrance on title unless you've been sued. So, you know, to kind of answer your question, kind of risky. Some people would perceive it that I'm not going to have any kind of an issue. It's great because it's not even going to appear on a mortgage certificate. It's not even technically a mortgage on my property. But if you get sued, and the person who's suing you for this negligent act that has generated this particular example files a lis pendens. And lis pendens is just a notice in the land records that a civil suit is proceeding against this person, it automatically converts that property bond into something that will appear on the mortgage certificate. And I think that's a good testable question. You know, exactly how does a property bond appear? And the fact that you'd have to know it involves litigation, but more importantly, it involves filing a lis pendens. Because if they don't file the lis pendens in conjunction with it, the litigation can take place civilly and there'll be no issue with it. All right, so I'll tell you a quick story about how these lis pendences work and how important it is that they get filed in the right place. So everybody in here familiar with workman's liens? Everybody know what a workman's lien is? No? So if you hire a plumber to come out onto your property and at the end of the job you don't pay the plumber, the plumber has a few options. Now if the plumber just came out to, you know, unstop a sink or something like that, the fee the plumber might charge you might be $100. It's not necessarily going to behoove that plumber to sue you for $100. But that plumber, because he provided labor and or materials to your job site, has the right to file a lien on your property. A unilateral affidavit that the plumber can take in front of any notary public and then go record in the land records that will prevent you, even though it's just his affidavit that you owe him money, it will attach to your property and will force you to address that lien should you decide to sell or refinance your house within the first 12 months of the lien. Now the law says that a lien by a laborer can't last in perpetuity. So a plumber can't go out there and file in your property and then 10 years later that $100 lien is still a burden. It says at the end of 12 months, that plumber has to file a lawsuit on that lien and file a lis pendens regarding that lawsuit in order for that lien to have any legal effect past 12 months. Now the term that I'm referring to is called prescription. That lien will prescribe in 12 months. Most folks refer to prescription as statute of limitations, the idea that something loses its legal effect simply because it's too old. So a client of mine who is in the spray foam insulation business goes out and provides spray foam insulation to your house, and the jobs that he does typically range anywhere from $2,000 on up depending upon how big the house is. And he did a $3,000 job for someone, and the $3,000 job didn't pay him, and so he filed a lien against their property. He's very familiar with the statutes, knew exactly when it was going to prescribe, and so before the lien prescribed, he went and filed suit. He went to the local justice of the peace. Why would he go to the justice of the peace? Under $5,000. It's going to be a little bit quicker, going to be a little bit cheaper. He can represent himself in that matter. So he goes to the justice of the peace. Now, the lis pendens he didn't do because he figured that, and he knew that in order for that lien to be canceled, that the person that did the work, the person that he did the work for would have to go to the court and get a lien and privilege certificate. And that lien and privilege certificate would show any third party whether or not there was any pending litigation involving this issue that would cause that lien to survive the 12 months. Are y'all with me so far? Okay. So when the 12 months is up, the lady that owns the house goes to court, gets a lien and privilege certificate, and she manages to get the lien canceled, despite the fact he sued her in small and justice of the peace court. How do you think that happened?
Because it was past 12 months.
Nope, it wasn't past 12 months.
The justice of the peace didn't
That's right.
record it.
That's right. A lien and privilege certificate is about what's going on in district court. It's not about what's going on in Slidell City Court and Justice of the Peace Court. If you want to proceed procedurally and litigate this lien issue to keep your lien alive, and you choose not to file suit in the same court where the lien is filed, the duty is incumbent upon you to put third parties on notice that the litigation is taking place someplace else. You have every right to bring this $3,000 proof of insulation suit in small claims court. It makes sense to bring it in small claims court, but you can't be upset because the clerk can't read your mind as to where you filed the suit. For all appearances, it looked like they failed to file timely and the lien was eligible for prescription. She managed to get the lien off her property and sold her house before you could get the judgment. And then there's no telling. I mean, at that point in time, once she sold the house, tracking her down and trying to get that judgment against her is really, really difficult. That's why the lien's nice, because the lien holds that amount owed to that plumber in the case of the spray foam insulator, the spray foam insulation job. It holds that amount on that property, and it really keeps that person from selling or refinancing their house without having to address it, whether that person's right or wrong. I mean, I'm sure that the lady didn't pay the plumber because she didn't think that he or she did a good job. I'm sure that my client didn't get paid because the person had some sort of dispute with the work that he did. There's always two sides of that story, but the lien on the property forces that story to be heard in court. But you gotta get that suit filed in the proper place, or get a lis pendens in the record to make sure that it doesn't proceed without you. Okay? All right. Page 64, acceptable bonds. It says the required bond need not be a commercial surety bond, but may be a personal surety or property bond. A commercial surety bond is a bond underwritten by a surety company authorized to do business in the state. A personal surety is a bond underwritten by an individual. A property bond is a special mortgage on a movable property in the parish of the Notary's Commission. Approval and recordation of the bond. The required bond must be submitted to the clerk of court in the parish of the commission. It must be subscribed in favor of the governor, approved by the clerk, bless you, and filed with the Secretary of State. The bond must be secured by a person who resides in the parish of the Notary's Commission or by a commercial surety company doing business in the state. Notary bond secured by personal surety must be acceptable to the presiding judge in the parish. In lieu of personal or commercial surety, the bond can be secured by a special mortgage or a property bond on property situated in the parish of the Notary's Commission. Such bonds must be recorded. Bonds secured by personal surety must also be recorded in the mortgage records of the several parishes where the principal obligor may own property. Commercial surety bond is not subject to recordation. Although the clerk of court must approve the bond, a commercial surety bond need not be recorded. Any reason why a commercial surety bond wouldn't have to be recorded? Doesn't attach to any property. There's not a piece of property backing it. It's a more traditional insurance product, and therefore its existence allows recovery against it. Its knowledge to third parties isn't critical to its function. Okay? Notary bonds not mortgage until lis pendens filed. The recorded official bond of a notary public does not operate as a mortgage on the property of the notary or the sureties, nor may it be included in a mortgage certificate affecting property of the principal or the sureties unless and until an action on the bond has begun and a notice of lis pendens is filed. My spray foam insulator guy could have gone to the land records, could have filed a notice of lis pendens that litigation was pending in Justice of the Peace Court. We wouldn't have had a story to tell. It had all been fine. But he figured that the fact that the suit was there was good enough. It's not. Clearly, you got to put people on notice of what's happening in the civil records by filing something in the land records. Y'all understand that the clerk of court's office is broken down into different books. There's a civil records, there's criminal records. Our clerk of court has a marriage license records, land records, miscellaneous records. In land, there's conveyance and mortgages. Not all of the books are linked to each other. Not all the information automatically rolls to the other. You have to know to look in multiple places for the information you're looking for in a lot of cases.
Right, I got a question for you.
Yes, ma'am.
Sometimes with the lis pendens, they recorded in both books. They recorded
Sure.
in conveyance. Why is that?
Just to make sure it sticks. The reality is it makes more sense to put it into the mortgage books because mortgages can be canceled. You can file something subsequent and then that lis pendens will show up as a canceled instrument. But people that are filing those things don't want to take any chances, so they record them everywhere. And the clerk's going to charge you on a how much and how many pages you got and where you're recording it. So the clerk's never going to say, oh, that's really overkill, you don't need to put it in all these. The clerk's going to say, sure, bring it to me, I'll put it here, 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 here's your bill. So people have a tendency, in my opinion, to over-record just simply to make sure those kinds of things stick. Now, you can get something out of the conveyance records, but you can't get it marked canceled. You got to get a subsequent affidavit filed that says that the previous lis pendens no longer has any effect, signed by the same attorney or by the same person that filed the lis pendens. You got to like have an offsetting affidavit.
Okay.
But there's a way to do that.
I was just curious.
Commission issuance. For a commission to be issued, the applicant must have met all the qualifications provided by law and file the following documents with the Secretary of State. And bullet point number 1 is certificate provided by revised statute 35-191C1B2, his oath of office, his bond, his official signature.
That was on the test.
That was on the test, Patty says. That was on the test. I think anything you see with bullet points is something you got to highlight because these are fodder for multiple choice questions. We provide the oath of office. If you would let us swear you in after you pass the test, we'll provide you the oath of office.
Can I ask a question?
Yes, you may.
How did they have it listed? I mean, did they have all of those bullet points as one?
Do you remember the question, Patty? She's asking what was the question that generated that answer.
They had a couple of others in there and you had to pick which ones were, or they threw in a fifth one and it would say everything except.
A and B, C and D,
Right,
right.
okay.
So they would give you these
All
4, and they would give you 2 more, and you got to be able to pick out the 4 legitimate ones.
And they look very close.
Very good.
Yeah. Dual commission, top of page 65. A notary may apply for a second and concurrent dual commission in and for a parish where he maintains an office. The application process is the same for commission in the parish of residence, and a separate bond must be given in each parish. No examination is required. Now, the dual commission is really kind of a throwback to the parish-wide notary. There's not a practical reason why you need a dual commission with the statewide jurisdiction. Okay, so a dual commission question in the context of a statewide jurisdiction problem is probably a rabbit hole. They're probably trying to send you somewhere hoping you can recognize the difference.
They had that too.
They had that too? All right. So I'm going to give you, so what they're saying is I'm going to give you, if I want to know that you know that dual commission is really more of a individual parish-wide notary issue.
It took more than the 40,000.
Okay, so I'm going to give you a statewide jurisdiction problem, and I'm going to throw in an element of dual commission and see if you can realize I'm leading you astray. That's the kind of question Dr. Matthews might present to you. Commission status, page 65. Louisiana notary commissions have no expiration date, but notaries must remain in compliance with statutory requirements in order to lawfully exercise the duties and functions of their office. We talked a little bit about this last time. How long is your notary commission once you pass? For life. Maintaining current bond, regularly commissioned. Non-attorney notaries are required to post bond in the amount of $10,000 secured by good and solvent surety or be currently insured for at least $10,000 in a notary errors and omissions liability policy in order to have authority to exercise notarial functions. Commercial surety bonds for Louisiana notaries must be renewed every 5 years. Personal surety bonds remain in effect for the life of the surety. Errors and omission liability insurance policy written for 1 year and 5-year terms depending upon the insurer and the amount of coverage purchased. Notaries required to post bond who do not maintain their bond or who do not file their bond renewal with the Secretary of State as provided by this revised statute 3572 are automatically prohibited from exercising the functions of notary by operation of law. So it's not like you got to wait for a letter, and it's not like you got to wait for a judge to call you or the Secretary of State. If you don't post your renewal, you're no longer able to exercise your functions as a notary public. Okay? And so when they say operation of law, what they're saying is that it goes into effect right away. We don't need certified letters. We don't need notice. Operation of law means a formal situation that takes place because the law says it does. Operation of law is a nice phrase. You'll see that throughout the book. They have a tendency to use that operation of law. That's why I want you to become familiar with it.
Once you find out you pass your test, you just go to get insurance? You find out and then...
Once you pass your test, you make a phone call to the insurance agent that's going to be providing you the bond or your insurance product. You got to get your oath of office signed. You go back to that page where where was that at? 64 at the bottom. Commission issuance. So Jessica, see, this is those 4 bullet points. That's what you do when you find out you pass the test. Those are the next 4 steps. Maintaining qualifications for office. In the opinions of the Attorney General, in order to remain in possession of an office, an official must remain possessed of the qualifications to hold the office. In the Attorney General's opinion, number 771341, that was issued in 1977, the Attorney General said, this act expressly limits one's eligibility to become a notary to the parish in which he maintains his residence, to one other parish in which he maintains an office. You see, the 77 pre-exists the statewide examination date. That's why the opinion says that. If a notary ceases to maintain either a residence or office in the parish in which he holds a commission, it is our opinion he ceases to be eligible to hold a notarial commission in the parish, and ipso facto forfeits his commission. Now, there are still notary-wide, or parish-wide notaries. There are still people who only have parish-wide commission. They still have to abide by these rules. So these rules are in the book. They're subject to being tested. People have to abide by them, but these rules won't be applicable to you as a statewide jurisdiction notary, and questions involving these two things are probably there to trip you up. All right, so then in an opinion he rendered in 1978, he says, the furnishing of a sufficient bond is an express requirement necessary in order to be appointed to the position of notary public. If one ceases to meet the qualifications of this office, it is our opinion that he ceases to hold the office. And then and then he states additionally, the requirement of maintaining an office means maintaining an office open to and for the general public as a notary public. So this is the part of that dual commission, where you've got a commission in the parish of your residence and a commission in the parish of your office. So you live in Slidell and you drive into New Orleans to work every day. They're saying if you don't actually have an office in New Orleans Parish where people can come and do notary business with you, you don't meet the element that they have of maintaining an office. Act 756 of the 2006 regular session codified the point made by these opinions. Commission validity is defined as revised statute 35-191A3. So when they say it codified it, what they're saying is that our legislature took the Attorney General's opinions and reduced it to law. And now what was his opinion back in the 70s is now statutory, it's now code. And they're actually giving you the code there, which requires that the notary maintain the qualifications for the office of notary in and for the parish and the commission in order to be considered validly commissioned. The qualifications in which commission validly rest or expressed in the law. Notaries must be commissioned in and for the parish in which they reside and are registered to vote. And if the notary holds a dual commission, he must maintain an office open to and for the services of the general public as a notary public in the parish of the second their dual commission. All commissioned notaries who relocate their residence must recommission in the new parish to remain validly commissioned. A notary's commission in the parish from which he is moving, however, shall be considered a valid commission for 60 days in order for the notary to meet the requirements of the appointment in the new parish. I think that's an important time frame. I can definitely see a question where the facts involve someone moving and not filing the appropriate paperwork within 90 days and making sure that you know the difference that they only had 60 days in which to get that done. Further, if a notary public who is a citizen is purged from the rolls of registered voters, his commission becomes invalid. The law specifically accepts the failure to maintain bond as a sole cause for commission forfeiture. It clarifies that the penalty for failure to maintain bond is statutory suspension of the commission and suspension of the authority to exercise official functions.
Are there any things that you can't do in conjunction with being a notary?
Like, can you give me an example?
Can you still work at the polls?
Sure. Levette does that.
Okay, it's just,
Yeah.
I was just wondering if there's some things that.
I'm not aware of anything. Like, if you
Okay.
gave me a specific example, could you be a notary in the mayor of Slidell? I would think about it, but I can't think of anything that because you're a notary you can't do. You know an answer?
No, not a notary.
Yeah, but you're gonna be. That's my point. You're gonna be. So that I'm not aware of anything.
No, I don't think it makes a difference.
Okay.
Mhm.
So as soon as you move, you have to get your license changed and, sorry, and send off to the Secretary of State that you met.
I think that if you leave the parish, you go to another parish. If you're going to move within the same parish, you need to give them the appropriate change of address, which you would probably do, if nothing else, through the annual report you've got to file, which we'll talk about in a moment. But as long as you're moving within the parish, I think you're fine. It's when you move outside the parish, you have an obligation to get your commission changed.
60 days.
60 days. Okay? All right, so the law specifically accepts the failure to maintain bond. We've read that. In summary, to be validly commissioned, the notary must, now I think these are important, have residence in the parish of the commission, be a registered voter in the parish of his commission, unless he's a resident alien, be currently bonded or insured, unless he's an attorney licensed to practice law, and 4, if holding a dual commission, not only maintain the commission in the parish of residence, but also maintain an office. 2, and 4, providing notarial services to the general public in the parish of the second dual commission. At any time these qualifications are absent, with the exception of commissioned notary or official leave of absence, the commission is invalid and the notary is not validly commissioned. Buffy, didn't you talk to me about the de facto doctrine? Weren't you the one asking about what happens when you're a notary, or when you're no longer a valid notary but you're notarizing documents? Somebody asked. If it wasn't Buffy, somebody asked about it. This is it. Page 67, the de facto doctrine. In practice, courts have routinely upheld the validity of acts passed by notaries who were not qualified at the time they executed the instrument, but routinely is not the same as always. There's always going to be some review, some element of subjectivity given by the court to determine if the document exercised by someone who is not a valid notary is going to be honored as if it had been. The de facto doctrine is far from an automatic validation of the notarial acts of a person who is not a notary de jure. That does not mean notary with gravy, by the way. Notary de jure, it rests with a court to... I know. It says the determination requires the existence of good faith on the part of the person exercising notarial power. The notary is not automatically a notary de facto when he loses his de jure status. Okay. Good faith is a big part of it. We're going to come to an example here in just a moment where I don't think anyone can argue that the notary was in good faith. So even good faith is not a guarantee that a de facto document prepared or executed by that notary is going to be deemed to be valid. But their mindset, their belief, the person who relied upon that person, and notary's belief are the kinds of things that are going to go into the determination as to whether or not that document can be deemed valid or not. All right, so it says, in order to understand the de facto doctrine properly, one must consider its opposite. The de jure notary is one who is duly qualified in and appointed for a parish in compliance with the laws then in effect. He is continuing in his lawful position by compliance with statutory authority with no irregularity or question about his lawful status as a notary public. The opposite side of de jure notary is the impostor or the usurper who has never been qualified and has no legal right to the office of notary public, but holds himself out as one nonetheless. That's not a de facto notary. This is someone who absolutely knows they're not a notary, but went to Office Depot, got themselves a little crimper, and they're in business making $10 every time they sign their name. That's going to be the usurper they're referring to. That's the opposite. The de facto is going to be that person in between. A de facto notary is someone in between. He properly acquired the office of notary public because of some irregularity or failure to maintain his status and ceased to be a de jure notary. Let's say they failed to file an annual report, failed to post their bond renewal, failed to notify the Secretary of State that they moved out of the parish and didn't get their commission reassigned. These are the kinds of things that they're talking about here. In such cases, a matter of public policy to ensure the stability of titles and acts of commerce, the law will afford some efficacy to acts received or passed before a de facto notary public. For an excellent discussion of the origin of the de facto doctrine as it applies to public officers generally, you should consider the Dauterive Jr. Henry J. Dauterive. Oh, that's just his treatise there, de facto public officers. Okay. The de facto doctrine protects the public from onerous task of having to verify the status of a notary's commission before securing notarial services. The doctrine operates in favor of the public and does not give validity to the commission. So, you know, it's not to say that someone wouldn't come to you and say, Shannon, can I see your credentials? Can I see that you've got your insurances in place? I want to make sure that you're a notary. What they're saying here is that's not the consumer's burden. It's not their burden. Not that they won't ask, but it's not their burden to have to confirm that you are, in fact, able to notarize these documents. So there's going to be some deference given to the general public when it comes to that. The Plauché case, page 67, and the succession of Darrell J. Plauché. Writ denied, the Court of Appeals upheld the invalidation of a testament executed by an attorney notary. All right, so here's the situation. I just got finished telling you it's not your job, it's not your burden to make sure your notary's qualified, that they have de jure status. This is an example where, despite the fact that this gentleman had been a notary, that they determined that the will was going to be invalid. Mr. Crittenden, Walter Crittenden, who was under suspension from the practice of law at the time the will was signed, he's the one that drafted it, he's the one that prepared it. The appellant's argument that the attorney was a notary de facto because both the testator and the attorney believed him to be able to lawfully exercise notarial powers was rejected by both the trial court and the appeals court in finding the will invalid. So what they're saying is that Mr. Plache believed Mr. Crittenden was a valid notary. Mr. Crittenden believed he was a valid notary, and despite these efforts to believe these things, or good faith beliefs of these things, the court still determined that the will was invalid, that he was not a de facto notary. They not only did the trial court say no, but the appellate court say no. When they say writ denied, it means the Supreme Court said this is so ridiculous, we're not even going to look at it, we're not even going to consider it. So it never even made it that far. Revised Statute 3514 provides that a disbarred or suspended attorney is prohibited from exercising notarial functions, and that statute states, any attorney at law or person who is an attorney at law who is disbarred or suspended from the practice of law due to charges filed by the Committee on Professional Responsibility of the Louisiana State Bar Association who has consented to disbarment shall not be qualified or eligible, nor shall he exercise any functions of notary public in any parish of the state of Louisiana as long as he remains disbarred or suspended from the practice of law in Louisiana. Okay, the court continued. The Louisiana First Circuit Court of Appeal held that it is self-executing and it is implicit in the Supreme Court's judgment suspending an attorney from the practice of law that the attorney is also not qualified to exercise a function of notary public. Walter Crittenden was suspended from the practice of law in June of 1998 by order of the Supreme Court, and he remained suspended until on March 8, 2002, the date he notarized Plache's will. The dude hadn't practiced law in 4 years, but believed he could still notarize this man's will. Okay? And so it says, in accordance with revised statute 3514, Crittenden was prohibited from exercising notarial functions on that date. Louisiana Civil Code Article 1577 provides that a notarial testament must be signed by the testator and witnesses in the presence of a notary, and also must be signed by that notary. Since Crittenden was prohibited from performing as a notary on the date the will was executed, on March 8, 2002, the will of Darrell Plache was not properly notarized and is therefore invalid. As a result, we affirm the trial court's judgment finding that on March 8, 2002, will of Darrell Plache is invalid. Okay, I did a little reading on this case. Plache and Crittenden were personal friends, and Plache knew it too. So it wasn't a situation where Crittenden was just the sole bad guy here who was notarizing documents 4 years removed from his eligibility to notarize documents. But the cases and the facts in the case supported Plache knew it as well. Okay, so Plache wasn't in good faith either, because that's really where I think you're drawn when you read this case. Is okay, Crittenden's a bad guy. What about Plache? What about poor Plache here?
He's dead.
He's dead, so he can't testify. Yeah, he's definitely poor Plache, but he can't testify as to what his good faith status was. But the facts of the case seem to indicate that he was in cahoots. Can anybody think of a reason why you want to get a will tossed out?
Yeah.
Well, tell me.
Yeah, if he doesn't have a, if he has a will written before then, maybe he changed it, or there's no will involved at all.
Right. So I can imagine that Plache maybe had 2 kids, and the will that Mr. Crittenden did gave everything to 1 kid, and if that will didn't exist, then everything gets split equally between 2 kids. So, you know, sometimes things aren't done properly, never become an issue, because nobody feels like anybody's been wronged in this scenario. So if Plache has a will, he's got 2 kids, and he leaves everything equally to both kids, we're probably not reading about this case. Doesn't mean that Crittenden did a good job, doesn't mean he wasn't a usurper at the time he notarized that document, doesn't mean Plache wasn't in cahoots to have an invalid will. It just means it wasn't subject to litigation because there was no third party interested enough to bring the litigation. Okay? Consider, this is at the bottom of page 68, or kind of the middle of page 68, it says, consider the importance of this decision carefully. The case is about statutory suspension of authority to exercise the function of notary public. Recently enacted changes in the law governing notaries in Louisiana provide for automatic suspension of the Notary's Commission and the authority to exercise the notarial function for any period that required annual report is not timely filed with the Secretary of State in any case where the notary is not properly bonded. All right, so going back to the Plache thing for a second, what if you think that he had been disbarred the week before he notarized the will?
It made a difference.
You think it made a difference? Anybody else agree with Sanjina on that? I agree with her. I think it could have made a difference. I think a person's good faith status could certainly be questionable within the first week. What if he was waiting on a certified letter from the disciplinary committee and he hadn't gotten that certified letter, or maybe he was still in shock from it, who knows? Or maybe he didn't know that by not being an attorney, he wasn't a notary. I just don't think that argument holds any water 4 years later. You know, so I think that when that happens in relationship to the event, certainly bears a difference on the judicial outcome of that. It doesn't change the facts, but it could have a judicial impact on the outcome. Notaries should take great care to maintain their de jure status, as a de facto notary doctrine might not be sufficient to validate documents executed while under a statutory suspension. Planche Supra may reflect a trend back towards technical statutory compliance in lieu of the de facto notary doctrine. If this is the trend, the notary's acts will be invalidated. So if you're a de facto notary, can you be liable for something that you notarize if you're a de facto notary?
Yes.
Absolutely. That's the reason why it's important to maintain your de jure status. Because if you're a de facto notary, even if you have E&O insurance, even if your bond's in place, they're liable to deny you coverage on the basis you failed to do all the other things you were supposed to do to maintain that coverage. Are there any insurance agents in here? I won't say what I'm about to say. I'm going to say it anyway. What happens is that a lot of times insurance companies look for reasons not to pay claims on policies. And so by all means, you not doing everything you're supposed to do in conjunction with it could be a reason why they don't provide you coverage, which means you're out there on the hook for the entire amount of damage yourself. You disagree, Jessica C? No.
I agree.
All right. Page
Corey had a question.
Oh, I'm sorry, buddy.
Just real fast, go back to the Planche case. I don't
Yeah.
want to drag it out too long. Wouldn't it go back to that operation of the wall?
Yes.
If, even if it was a week after he
Mhm.
was disbarred, right?
Oh, absolutely. That's what I'm saying. It doesn't change the facts. He's a de facto notary when he exercises the will, or he notarizes the will a week after he's been disbarred. My comment was the idea that a court could still give a document legal validity if executed by a de facto notary. The courts could have ruled differently in that circumstance. If he had been a week out, the judicial district court might have said, you know what?
It's just a decision.
Yeah, oh, absolutely. The decision to hold the document invalid
Okay.
was not driven by his de facto status. In my opinion, based on everything we've read to this point, the decision to hold that document invalid is driven by his bad faith status. 4 years after he's been disbarred, he's exercising functions as a notary public. 1 week after he's disbarred, he might have gotten a little bit of credibility with the courts if he'd have got there and said, I didn't know. I think it's easier to believe good faith at that point. But you're right. You're 100% right. The de facto issue does not change. The potential legal outcome changes based upon how long it is after, in my opinion. Okay? Annual reports. Oh, listen, caveat notarius on top page 69. For any commissioned notary to remain qualified to exercise notarial functions, the notary must be presently possess the qualifications for the office of notary public in and for the parish where he is commissioned. That is to say that he must be commissioned in his parish of residence, be a registered voter, unless he's a resident alien, in his commissioned parish. 3, he is a licensed Louisiana attorney and Louisiana resident, have a current bond or proof of insurance filed. Further, if holding a dual commission, the notary must not only be validly commissioned in the parish of his residence, but also must be actually maintain an office open to and for the general public for the purposes of providing notary services in that parish. We've kind of covered all that. They just kind of put a little snapshot right there. We've covered all those things already. Page 69, all non-attorney notaries except those who have retired and elected special commission status and those who have received leaves of absence are required to complete, sign, and file an annual report with the Secretary of State confirming their qualifications for office, their mailing address, and the status of their bond. The Secretary of State is required to make an annual report form available to notaries 60 days before their commission anniversary, which is the due date for its completion and return to the Secretary of State. Financial penalties and commission suspension accrue to notaries who fail to timely file the required annual reports. Annual reports are nice. Secretary of State essentially sends you the report, and if nothing changes, sign it and send it back with a check. What's the check? $25?
$25.
Yeah. If something's changed, scratch it out, put in the new information, send it back with
$30.
Oh, $30 for changes?
It changes has to be notarized.
And the change has to be notarized. But you should have a friend who's a notary who'll notarize it for you. That won't be a problem. Active notaries. Revised Statute 35-202, Subpart A, except as provided in subsection F of this section, all regularly commissioned non-attorney notaries shall file an annual report to Secretary of State on or before the anniversary date of his commission on the form developed and mailed or provided by electronic means by the Secretary of State pursuant to Revised Statute 35-191-22A. Together with payment of the filing fee established by the Secretary of State pursuant to that statute, the annual report shall be completed in full and signed by the notary. I think our Secretary of State is top-notch when it comes to website and the accuracy of the information on his website and the ability to communicate and do things through the website. Our Secretary of State's got.
So for a notary, you have to do it manually? Because I know we file electronically annual reports.
I don't know, does the Secretary, you would be able to file electronically because the Secretary of State has a number of mechanisms where you do electronic signatures.
We just get a postcard.
And you do online
key in
payments,
there.
right, and you do online payments, but I don't know if, I haven't looked at it, so I don't know. But I know that the technology is there for you to do electronic signatures and payments online, which would suggest to me you could do it online. But I know that I get a little postcard out from my corporation and things from the Secretary of State saying, hey, these things are coming due, and I typically get a letter that I sign and send back with a check if you're still one of those people that writes checks.
I just have gotten a postcard.
Just the postcard? All right, subpart B, except as provided in subsection F of this section, notary who fails to timely file the required annual report and pay the filing fee pursuant to subsection A of this section shall be assessed a late fee not to exceed $50 by the Secretary of State. The commission of any notary who fails to timely file his completed annual report within 60 days after its due date, as provided in subsection A of this section, shall be automatically suspended. The notary shall have no authority to exercise any of the duties or functions of a notary public until a current required annual report has been filed, and the notary has paid all accrued fees and late charges for a period not to exceed 3 years in connection with the suspension of his commission. All right, page 70, notaries on leave of absence. A notary granted a leave of absence by the governor pursuant to revised statute 35-131 or 132 shall not be subject to the fees or penalties established by subsections A, B, or C of this section during the term of his leave of absence. However, a notary granted a leave of absence shall provide the Secretary of State with a current address during such leave. Notaries electing retired status. A regularly commissioned non-attorney notary who is 70 years of age or older shall be permitted to elect a special commission status upon retirement from active service as a notary public by filing with the Secretary of State a written request for such status, along with an affidavit attesting to such status and certifying that he will no longer exercise the duties and functions of a notary public during such time as his status is in effect. A notary with such inactive status shall not be required to maintain a bond or file an annual report. However, notary granted inactive status shall notify the Secretary of State of any change of address to ensure the accuracy of information contained in the notary database maintained by the Secretary of State. A notary may resume active commission status by filing a current annual report with the required fees with the Secretary of State and posting bond the amount then required by law. So you can retire, you can come out of retirement and go right back to being a notary. Leaves of absence, middle of page 70, notaries who expect to be temporarily absent are entitled to leave of absence. It says the Secretary of State on behalf of the governor may grant leave of absence to notary publics for a period not exceeding 36 months to date from the day the leave is granted. Absence from the state suspends the running of prescription against the notary. Absence from the state suspends the running of prescription against the notary. Anybody have an idea what that means? So in your capacity as a notary, you could notarize a document that could have a fatal flaw associated with it. You could have liability associated with that document. Time heals most wounds. So in situations where there may be some liability, the clock may be running against you by the person who has the ability to make this claim to bring the action. If you file a leave of absence, the clock stops and it suspends prescription. So let's say you've done something and you've got a 3-year window. This person has to bring this claim. I'm just picking 3 years. They got a 3-year window in which they've got to bring this claim. And the 3 years were 2 years into it. You apply for a leave of absence. You for whatever reason, you come back 2 years later. You still got 1 year left. The guy's got still 1 year left to file suit. The clock starts ticking again. It gets suspended by your leave of absence. I think that's a great potential question, test question. That you know the difference between the idea that prescription does or does not run against the notary depending upon their status or their absence status. Notaries in military service leave of absence. A leave of absence may be granted by the Secretary of State on behalf of the governor to any notary public upon his application to the Secretary of State in writing, certifying that he is a member of the Army, Navy, Marine Corps, or any other branch of the military service of the United States, or the state of Louisiana, and stating the expiration date of his bond. Every state make special concessions for our military personnel. When it comes to the formality associated with the documents that they execute, when it comes to running absences for their being deployed, there's special rules when it comes to a person being in the military, being deployed as it pertains to their leases. There's always special concessions given to the military in these scenarios. The period of the leaves of absence granted in accordance with revised statute 35-132 shall date from the day the leave is granted and shall terminate 60 days after the date of discharge of the notary from the military service of the United States to the state of Louisiana. An absent notary is required to provide a current address to the Secretary of State during such leave. All right, page 71. Any questions about anything we covered so far? This is all statutory, not a lot of really interesting stuff in here, but certainly a lot of testable material in here. Any questions? Anything I want to talk about? What about you, Cody? Any questions you want to talk about? Good? Notary fees in Louisiana are not fixed by statute. In cases where the notary is acting under the supervision of the court, such as when appointed to make an inventory, the court may fix the fee of the notary. Such fees have the character of law charges, and the notary has a privilege for the fee. So if the judge appoints Shanna to do an inventory of a deceased person's estate, Shanna can't come back with a bill of $18,000. Okay? The judge is going to say, Shanna, I need you to go take an inventory of this person's house, and the fee you can charge is up to $1,000. That's when they say the judge can fix the fees, the judge has the discretion to fix the fees. You don't have carte blanche to charge whatever you want. That stinks, right? When it says you have a privilege for the fee, okay, the privilege is very similar to that privilege that the plumber has when he or she goes onto your property and you don't pay them for fixing your toilet. It's a privilege that you are entitled to be paid ahead of the heirs, the people that are otherwise inheriting the deceased person's property. You've got a right to be paid before them, because without your service, they couldn't have gotten that far in the succession. Okay, so it's a privilege that allows you to be paid in advance. Otherwise, the guiding principle is that the fee be reasonable and customary for the notary's locality and commensurate with the services performed. And so I had a lady come in my office a few months ago, and she looked like she was just a little down on her luck. And she walked in, and I just happened to be up front, and she walked in the front door, and she said, hey, y'all have any notaries here? I said, yeah, I'm a notary, I can help you. And she said, what do you charge? And I said, what do you need notarized? And she had an affidavit. I don't remember what it was for. She had an affidavit. And I said, for that, $20. She goes, I don't have $20. And she started trying to walk out. I said, well, wait. I said, you have $10? And she said, no, I don't have $10. I said, well, how much money do you have? And she says, I have no money. And I said, today's your lucky day. Come on in, I notarize it for anyway. We don't have a mandate on what we have to charge. I'm not suggesting you got to do anything for free, but we don't have a mandate on what we have to charge. We have some discretion when it comes to that kind of stuff. But the idea that it should be reasonable just makes sense. Okay, it just makes sense. A notary's signature is his seal. What does that mean?
Your signature is makes it official.
What about the little crimper? What does that crimper do?
Just
It
confirm.
just shows that it's an original.
Yeah.
Okay, that's really what it does more than anything else. It shows it's an original. You run your finger over it, you feel it, and you know it's an original. And so I had a client of mine that was in small claims court. He was having a dispute with his girlfriend over an issue with a damaged vehicle that they own together. And I had to sign an affidavit for him. And he actually lives in Alabama, and his girlfriend that he co-owns a car with lives here in Louisiana, and he was suing her here in Slidell in small claims court. And he drove in from Alabama, and he needed me to notarize an affidavit signed by his sister-in-law attesting to the fact that she saw the girlfriend damage the car. And so it was just late. He called me up at 8 o'clock one night and said, hey, I know this is out of the blue, but is there any chance you come over here to my sister-in-law's house and notarize this document? She doesn't live too far from me. So I said, sure. I get over there and I sign. I don't carry around that crimper. I don't carry around all that stuff. But I went over there and I signed the affidavit, and he goes, wait a minute, don't you need to crimp it? Don't you need the seal? And I said, you're suing her here, right? And he says, yeah, I'm suing her here. I said, then no, my signature is my seal. Now, if he was suing her in Alabama and he needed an affidavit from the sister-in-law here, then all of a sudden you treat that document with a little bit more formality, because you don't know what Alabama's rules and regulations are when it comes to documents being sealed. And you always want the document to have the effect it's going to have in the state it's going to, not in the state in which it's executed. The idea that we don't need crimpers on our notarized documents here doesn't carry a lot of water in a small claims court in Alabama. So as long as it's here, we're going to be fine. And so I didn't have to seal it. I don't have to seal anything. Now, I tell you what we do as a title company, we have a red notarized stamp. And we do it for the same reason that Robin talked about. We have our client sign in blue, and then we notarize in red, and then we photocopy in black and white, so that there's no question that we're dealing with the original as opposed to a copy. And that's a big, big thing, you know, because original documentation is a big part of what we do in our practice as a notary. The crimper's great for that. It's great for that purpose. But it takes a little effort to crimp all those documents. So if you gotta notarize, exactly, and then multiple copies, everything else, it's a lot of work. So the little stamp works great. And Office Depot gives you those stamps for like $20.
Yep. And they last forever.
And they ring them for you, they last forever. So we sign in blue, notarize in red, photocopy in black and white, and that's how we avoid having to crimp the documents. And like I said, that's not because it has to be done procedurally. We do that so that we can distinguish originals from copies. So there's a difference. We don't. You've been in closings. Everybody signs in blue.
That's what you said.
Everybody signs in blue, but what you don't see is that we'll go stamp everything in red afterwards. And so we've got red and blue on the paper. When we photocopy it, there's no question we got the original or the copy. All right, in the Fleming versus Richardson case, the Supreme Court instructed that in the absence of law to the contrary, a notary is not required to have a particular style of seal or give authenticity to juridical acts. In other states, a mechanical or printed seal is often required. That's why if you're sending something out of the state, you want to treat it with a little bit of formality because you don't know where it's going, what they're going to require. And nothing is more aggravating or embarrassing than trying to justify why this document doesn't work where it's going, especially if they give you any instructions when they send it to you to begin with. All right, so accordingly, the public has come to expect that more than a signature to be present. Although Louisiana does not require the use of a mechanical seal or stamp, it is good form to use one. It becomes practical necessity when the instrument is intended for filing outside the state of Louisiana. Otherwise, the recipient might reject it for lack of the seal. I knew an attorney who used to walk around with this big, put it on the desk, kind of a thing. And I remember watching him carry that into a closing one time, thinking to myself, oh, I can't do that. He set it on the table, but he made a big production out of it. And I think what happened is that it just became part of his shtick. You know, there was this formality that he kind of created in his practice, and he just never was able to shake it. Identification of the parties. The notary must exercise the care of a reasonably prudent businessman and ascertain the identity of an affiant or a party executing a document. A state-issued driver's license bearing a photograph of the party is the customary identification document required by notaries. What about passport?
It's good.
It's okay? What about a Sam's card?
No.
I mean, Sam's makes great efforts to make sure that you know who you are. No? So you see, any government-issued identification, okay, military IDs, passports, and that's kind of the standard by which we operate. If you've got government-issued identification, that's sufficient for me. If you've got anything else, I'm not real happy about it. So what about a Social Security card?
Doesn't have a picture.
Doesn't have a picture. That's why Social Security cards don't work. Now, you will occasionally, if you're doing business with a bank and you're notarizing something in conjunction with the bank, they will ask for a secondary form of government-issued identification, and they'll take a secondary form with no picture ID as long as the primary form has a picture on it. So Social Security cards work, but they typically only work as a secondary form. Okay? It says, in the Halcott versus Talon case, the court said where a person appearing before a notary public is identified by another person known to the notary and whom he has no reason to suspect of wrongdoing, the fact that the notary is in good faith receives the acknowledgement of the person still appearing to an act of conveyance or other instrument does not subject him to liability for damages, though such person be not the person whom he was represented and believed to be. That's kind of interesting. So they're saying, hey, you can notarize for something you don't know, and you're not going to be liable for it under this particular set of circumstances. But let's read them again to make sure we know exactly what the circumstances are. Where a person appearing before a notary public is identified by another person known to the notary. There is the catch. So if Jessica C. comes in and she says, listen, this is my friend Jessica, and here's my driver's license. I'd like you to go ahead and notarize this document for her. I'm going to vouch for her. Jessica's not known to me in that scenario because she had to present her driver's license to me in order for me to be able to know who she was to begin with. Whereas a dad comes in and dad says, hey, look, this is my buddy and he's lost his driver's license. Would you notarize this affidavit for him so he can sell his boat? Well, Dad's known to me. So therein lies the difference. So if you know the person and they make a representation, there may be a basis for you not having liability if the person it turns out not to be that person, okay? But for the most part, never try to put yourself in these situations. You want picture ID for everybody that you do notary work for. That's my personal policy. I don't take the words of other people. I don't even take the words of people that are known to me, just to avoid the potential circumstances, just to avoid it. But they're saying that's a scenario where you could. The key phrase, known to the notary, when one person, no matter how valid or proper his identification document may be, is not known to the notary, attests to the identity of another person for the purpose of an appearance in a notarial act, it is not reasonable for the notary to accept the word of the one party as to the identity of the other. You see? See? No? All right. In such a situation, the notary has ascertained nothing, since the notary has no way of knowing enough about the person making the identification to be reasonably assured that there is no possibility that something may be amiss. In the Collins versus Collins case, page 72, it says the notary was held liable for fraud for failing to properly identify the parties to an act passed before him. And I'm going to share this with you. I'm a real estate title examiner. That's what I do. For the most part, I come to work every day, and I look at real estate abstracts, and I do title exams. And so I kind of came up in my practice working with attorneys that did that as well. And they talked about this Louisiana case where a woman went to a closing and sold her husband's house without the husband being there. She and her boyfriend went to closing and they sold the husband's house. And the husband came home from work and all the furniture was out of the house and people were moving in, and it turned out that the boyfriend was the recipient of the proceeds of the sale. And I never believed the story. I never believed. It was just too much of a crazy scenario. But that particular story is actually grounded in the Collins case. There is some truth to it. When you read how this happened, it actually makes a little sense. Miss Collins and a man claiming to be Mr. Collins appeared before a notary in Louisiana to execute a sale of a piece of property located in Florida. There's the big change right there. The property wasn't here. That's how the husband was kind of duped into this happening, because the transaction was taking place someplace else. Because I often thought to myself, how does the husband not see people coming through the house and taking measurements and negotiating contracts? How does that not happen? It's because the real story didn't involve a house he lived in. The property had been acquired during the existence of the Collins marriage. Mrs. Collins identified herself to the notary and introduced her husband to the notary, who apparently relied upon Mrs. Collins' statement identifying her husband. Now, if that notary knew Mrs. Collins personally, if then Mrs. Collins was known to the notary, there might be some defense under what we just read. But apparently in this case, he didn't know Mrs. Collins from Eve. There you go. Consequently, he relied upon maybe her driver's license and her representation that this was the husband. There is no indication that the husband provided any identification other than that of the ex-wife's introduction. Subsequently, a man claiming to be the real Mr. Collins filed suit to have the sale set aside and recover damages from the notary. The court relied upon a previous decision in the Summers Brothers case, in which the court reasoned that even if the notary did not know that the signatures in the contract were forgeries, he knew that by authenticating the document as a notary, he was telling the world that the parties had appeared before him and affixed their signatures in his presence. Thus, he committed fraud, and that he purposely let third parties rely upon a document purporting to be genuine, but actually without validity as an authentic act. The proof of the validity is supplied. What he supplied was misleading to all who relied on the contract. What they're saying is, hey dude, it's not that you had to be in the scam. It's you allowed the scam to take place. And had you done your job in the manner that you were supposed to and collected the identity of all the parties that you affixed the documents for, we wouldn't be having this conversation. What do you bet?
Hope we had more than that $10,000.
That's exactly what I was going to say. What do you bet that was more than a $10,000 problem? I would think it'd be more than a $10,000 problem. All right, the signature in Summers Brothers as Incorporated of the purported husband was in fact a forgery. The court likewise held that the notary who passed the mortgage was deemed to have committed fraud because he notarized a document where someone had forged a signature. The notary isn't culpable. He's not saying, hey, just forge this person's signature. He's not culpable in it, but he notarized something that had been fraudulently signed. Therefore, he was culpable in the fraud. Or therefore, he was liable as if he was involved in the fraud. Because the notary's failure to properly identify the parties was considered fraud. The husband's right to sue arose from the date of discovery of the fraudulent act and was not prescribed. While it may appear that the notary was merely negligent, the failure to actively and properly identify a party to the act constitutes fraud. So let's talk about prescription didn't run until knowledge of the act. There's two different ways prescription runs in situations. And prescription, if you recall, is the statute of limitations. It's this idea that even though we can make a mistake, we won't be responsible for it if enough time passes before the issue is addressed. So what they're saying is that prescription typically runs when you knew or should have known about the problem. And so I know about the problem, I choose not to do anything about it, then all of a sudden at that point in time we can say prescription ran from the point that I knew. What they're saying is that prescription never ran in this particular circumstance because they didn't know it was a forgery. And the moment they knew it was a forgery, that's when prescription runs. So it's not from the act of the forgery itself, and it's not from the notarization of the forged signature because no one knew about the fraud. When the fraud became known, that's when prescription starts ticking. Okay, so it's knew or should have known. Liability. The notary is personally liable for damages, and the surety is bound to the limit of the bond when a person suffers financial injury caused by the notary's failure to faithfully perform his duties. Causes of action. Circumstances giving rise to damages chargeable to the notary and the surety occur when, bullet point, notary commits misfeasance or malfeasance. And the definition of misfeasance is the improper performance of a lawfully authorized official act. Malfeasance is the wrongful or unlawful conduct by a public official. The notary acts in dereliction with negligent disregard for proper performance of his official duty. Persons act in reliance upon the genuineness of the instruments the notary executes in his official capacity when those persons are defrauded through such reliance. This is not an exclusive list. Top of page 73. This is not an exclusive list of causes of action for which the notary might be held liable. There is no duty to inspect instruments or guarantee validity. Where a notary is engaged only to attest to or authenticate the signatures of constituents or instruments prepared by someone other than the notary has no duty to inspect the document for legal flaws or to guarantee the validity of the document. Donna, does that sound familiar?
Yes.
Donna and I actually had a conversation. She was trying to get a document notarized today, prepared by an attorney in Georgia, right?
There's also an attorney here.
Also an attorney in Louisiana.
She passed the bar in Louisiana and also in the state of Georgia. It's my sister.
Right, and you couldn't get a notary to notarize it because they didn't prepare it.
Nope, and when I brought it up to him saying that you could attach, I asked the third notary that they could attach
The disclaimer.
a disclaimer after I spoke with you.
Mm-hmm.
And no, can't do it. We did find finally a notary, and I still don't know how this guy got my number to call me back because I was calling so many people. And he said, oh, go to this address, I'm going to call him and tell him it's okay. When I got there, the notary is supposed to be an attorney of a firm.
Mm-hmm.
Okay, so. Anyway, she retyped it in her fashion as if she executed. In other words, she did a whole new will.
All right. So the idea, because when we're talking on the phone today, I'm telling you shouldn't be dealing with this.
Right.
Because right here on page 73, where a notary is engaged only to attest to or authenticate the signatures of constituents or instruments prepared by someone other than the notary has no duty to inspect the document for legal flaws or to guarantee the validity of the document. No duty.
Okay, but you know, I hear exactly what you're saying. So as long as we were willing, my mother was there who was going to sign it.
Right.
With proper identification,
Mm-hmm.
right? If they notarized her signature, she said, we don't do it because we're called into court if there's something wrong with it. I'm thinking, you're not saying that this is, you know, so anyway.
Notary attests to the signatures only is a
Right.
stamp we have in our office. Notary attests to signatures only. Look, I'm not suggesting that you go throw your signature on every document that's out there for $20 a pop. I'm not suggesting that at all. But, you know, Donna's a good person and she's got one day off and you got your mom and you're trying to get some business taken care of. You come into my office with that particular set of circumstances and I tell you, Donna, I'm not comfortable with this document, but if you don't mind me disclaiming liability for notarizing it, I'll notarize it for you.
Believe me, I almost drove the slide down.
Yes, ma'am.
Can't you just put a stamp that says that wasn't or this document was not drawn up by
Yeah.
myself, and that as long as that's on there and you're notarizing it, you should be.
Absolutely. Now, it can say notary did not prepare this document, not responsible for the content thereof. Notary didn't provide a title examination. I mean, there's actually a page towards the back of the book with a list of disclaimers notaries should use in all these kinds of circumstances. We have one that simply says notary verifying the attestation of signatures only. Is that what it says?
That's all we want.
So that's all it says.
That's all we want.
And now what the lady tried to tell Donna was that, hey, look, there's a problem. I get drug into court. I get subpoenaed. I got to take a day off of work. I got to come in. I got to testify. And so what I think she's trying to tell you is I see more trouble in this document than the $20 you're going to pay me justifies me being involved in. That's what I think she's saying.
But if she had done this,
That doesn't keep her from being subpoenaed. Doesn't keep her from having to come in. And so what I think she's saying, and listen, people establish policies within their own companies as to what they will and will not do all the time.
Right.
And policy is policy, and it doesn't necessarily have to be consistent with the law. And policy is policy. That's all there is to it. And so, unfortunately, Donna ran across a couple of notaries whose policies were we don't notarize those kinds of documents.
And an attorney who said, no, if I didn't draw it up, I'm not notarizing. An attorney.
These people are making policy decisions. They're
Yeah,
making
that's
policy
fine.
decisions that they don't want to be involved because of the
They make more money if they
potential.
do that.
Well, yeah. Now that's a good point. You know, I'm gonna charge $20 to notarize. I'm gonna charge you $300 to redraft it. Cody said he'll notarize it for you. I agree with you.
Because we were in Mary, my mom was
I agree
old,
with
and
you.
she was already upset that we had to do it. Really, I wanted to drive her here. If I would have had my two sisters with me, we'd have been in Ray's office.
All right. Limits of liability prescription. This is I don't know if we're gonna have time to get to that quiz tonight. You might just have to take that quiz home. We'll see. No statutory limit exists with regard to the amount of damages for which the notary may be liable. The revised statute 35-200 establishes a prescriptive and preemptive period for bringing an action against a notary public or an enterprise answerable for the acts of a notary. No action for damages against a notary public for an act, omission, or neglect in the exercise of notarial function can be brought unless filed in the court's competent jurisdiction and proper venue. Within 1 year from the date of the alleged act, omission, or neglect. Within 1 year from the date of the alleged act, omission, or neglect is discovered or should have been discovered. In no event after 3 years from the date of the alleged act, omission, or neglect.
And this
So-
is probably on every test.
Yeah.
I think it is, and if it's not, it's going to be, I promise you, in some way, shape, or form.
The preemptive period does not apply in the case of fraud as defined in Civil Code Article 1953. Okay? So, the three prescriptive timeframes, and the one we were talking about, the forgery a little while ago, it generated from the time that they knew about the forgery. That's the reason why the 3 years prior to didn't count, because it says, in no event after 3 years from the day of the alleged act, omission, or neglect. Well, it's been more than 3 years, but it had been 3 years since we knew about the forgery, and that's what caused the second bullet point to go into effect. Top of page 74, notaries and the unauthorized practice of law. A narrow line, often difficult to discern, exists between functioning as a notary and engaging in the unauthorized practice of law. And so I've heard many notaries consult with clients, and I've heard them say, look, I'm not an attorney. And they can't give legal advice, and it's a very fine line, because the reality is you're doing an awful lot of legal work for people. And, you know, helping them with their last wills and testaments and things of that nature certainly starts to kind of cross the line. And so you've got to be very careful with that, because someone could make the allegation that you are in the unauthorized practice of law depending upon how you handle clients. Gregory DeKaiser, attorney, notary, author.
About the answer.
Yes, ma'am.
In capacity as a notary, what is the law of going to I know we talked about this before, like a nursing home or say a hospital bed and notarizing a will?
What's the law? The law is...
He does it all the time.
Yeah, I do it all the time. The law is how competent and what capacity is the person that you're notarizing the document for. Were you here the night that I told you a client of mine wanted me to come to a psych ward and notarize a document for her sister, and I said, just the fact I'm walking into a psych ward, I think automatically brings some doubt as to the validity of the document or the capacity of the person executing it. Just that fact alone was enough to drive me away from being involved. But if she was just at SMH and on the 1200 floor in room 1206 or something like that, and she was there because she had a gallbladder attack, I'd have no reservations whatsoever about going in there.
Like a 90-year-old man had a heart attack, probably.
If I walk into that room and that 90-year-old man looks at me and we can have a conversation and I can have a couple of, I typically kind of walk in and I verify their identity and I'll have a very brief conversation with them. And if I feel like in the context of that conversation that they're lucid and they understand what I'm there to do, I'm going to notarize that document for them. 90-year-old people need documents notarized too. Probably in some cases more than other people. Now, more often than not, they're notarizing documents that need to be witnessed, powers of attorney, living wills and things of that nature. And I'm going to have witnesses in the room and I'm going to ask a few questions. I'm going to look back and I'm going to say, do either one of you feel as though this gentleman doesn't understand what he's here to do or what I'm here to do for him? And if one of those witnesses was to say, I don't think he does, I'm walking out.
Doesn't a physician have to be in there?
The living will establishes a procedure for when you pull the plug that is driven by a physician's assessment of your condition, but the physician doesn't have to be present when the person makes a declaration to pull the plug or not pull the plug. That's where I think maybe, okay?
Well, like in that case, like where the notary went to the hospital bed, got the power of attorney signed, the gentleman. She stole $330,000 within 6 weeks of his money while he was in the hospital.
Oh my God.
And it was while he was notarized, she notarized it there.
Yeah.
The witnesses and everything.
Yep, that happens. Now,
She's in jail, the person that...
The notary?
Not the notary,
oh,
no, the person.
Right, the person that stole the money who committed the fraud.
Yeah.
We
But she
had
had a notarized power of attorney.
That's right. But the notarized power of attorney doesn't allow you to steal the principal's money. So she didn't act in the faithful performance of her duties as the agent of the power of attorney. I can't fault the notary. Now, I have turned people down. I've had people come in with their moms and their dads, and I didn't feel as though their moms and their dads had the capacity to understand what they were signing. I got a very good client of mine, a very, very good client of mine. I had no idea he was struggling with dementia to the degree that he is. He was in my office recently. I noticed that his wife had been handling most of their business and that he wasn't involved. And I just figured he was busy or he was retired, whatever the case may be. And he was in my office the other day, and I walked up to him and said, "Hey, how you doing?" Kind of put my arm around him and said, "I haven't seen you in a while. How's everything going?" He goes, "Oh, it's going great." Who are you again? And I said, "Oh my goodness." And the wife kind of got all nervous because she hadn't done anything legally about it to this point in time. She's not had him interdicted. She's not tried to take any action, but he's clearly slipped. Well, if he were to walk in right now and his wife was to say, "Would you notarize this power of attorney for my husband who you've known for years and years and years?" I'd say no. You know, had she walked him in before I had that conversation and she said, "Hey, would you notarize this for my husband?" I said, "Hey, how you doing?" And I would have notarized it for him if I saw him sign it, because I had no idea. So the notary's culpability is driven by their good faith and bad faith. And people that are sick can often come across as not being sick.
Well, I said in the courthouse, and Judge Garcia, that was a big case, and I actually got drug into that case because I sold a piece of land to the people who actually stole the money.
Oh, yeah?
A huge ordeal. Judge Garcia read the right act to
the notary.
The notary. I mean, I'm talking, he would talk her and told her.
Yeah.
I mean, he was not very kind to her.
My partner tells a story. Were you going to ask a question?
No.
My partner tells a story about how he was called into St. Bernard to meet with someone about a power of attorney. And he was there, and it was a lady, and it was her son. And the issue was they were there to revoke a power of attorney that she had previously issued to her daughter and to grant a power of attorney to him. And she seemed fine. You know, her hair wasn't disheveled, and she was dressed appropriately, and she certainly seemed like she had everything going on. And she was sitting next to her husband, and my partner starts talking to her. And every time he asks her a question, the son jumps in with the answer.
That's what I was about to say.
Okay, the son jumps in with the answer. 3-4 times this goes by. Every time he asks her a question, son jumps in with an answer. So finally he asks her a question and he says, "I want to hear the answer from your mother. Don't answer this question." And she said, "It's beautiful today." And he looked at the son, and the son says, "Well, she has her good days and she has her bad days." He goes, "This is not a good day, and I'm out. I'm not going to be involved in this."
that's what I was gonna say,
Okay.
that if the person doesn't answer the question, if a relative or somebody is always constantly stepping in,
Red flag.
answering for them.
Red flag.
And
So-
you know, I have an even crazier situation.
What's that?
Because my husband had brain surgery. So he understands, he reads, but he has a speech impediment.
Oh, so he has a hard time communicating. So he's
Yeah.
cognitive, but he has a hard time communicating. So he may not come across as having capacity in the conversation.
Yeah. It's scary.
Can he write it out though?
Well, he
I'm
can,
just curious, that's not really my
sometimes he
business.
can and sometimes he can't.
Oh,
But
okay.
what we did, because I'm like, how do you do an eye test with somebody who does this? And the eye doctors would say, well, point up, down, left, right, you know, and he'll start with little things. And then as you're talking to him, you can pretty much understand what he's trying to get, but it takes a while, you know, it does.
Yeah.
It's kind of scary, because like police stop you for your license, and
Oh,
they
yeah.
automatically think he's drinking,
Right.
and he's not, had dropped.
So in this particular situation where he reads the notary the riot act, does he sanction the notary? Is the notary
Yeah, she
sanctioned?
was sanctioned, yeah.
She was sanctioned?
Because there was, the gentleman owned 2 homes on one piece of property, and not only did the gentleman had never, he had like $800-something thousand, he wasn't in a bank account, and he had never spent more than what, like $500 a month, I think it was. And he didn't have any kids, he only had nephews, and his wife had died, and he just lived alone. He just never messed with anybody. His wife had died in the one house, and he couldn't live there. So he goes into a small house, and he had that one. He rented the house to them. They moved in, they started taking care of him, and apparently whatever went on, and she discovered that he had this money, got the power of attorney, the Rebecca lady signed the power of attorney. They did an act of donation of all of his property to them.
That's terrible.
So then they owned all of his property.
Did that notary pass the act of donation? Or just the power of attorney?
She did all of it.
Okay. Therein lies the problem. Therein
It's
lies the
backing
issue.
up the issues.
Well, because what happens is that, you know, if the notary gets sanctioned for notarizing the power of attorney, when a person has the ability to come across as having capacity, I disagree. I don't have any place to disagree with Judge Garcia, but I disagree with that assessment. The powers of attorney that allow you to self-deal have to explicitly allow self-dealing. And so, if I notarize a document for you, and then you take that power of attorney to me, and I say, listen, I can't pass this act because there's no provision in here for self-dealing, and then I roll back to you as the notary did the power of attorney, and you let that go, that is a basis for being sanctioned, because you pass an act where the power of attorney didn't explicitly allow self-dealing. If the power of attorney explicitly said, I give you the power of attorney to be my agent, and in your capacity as my agent, if you choose to self-deal, take my stuff, buy my stuff, sell my stuff at a discount, that's entirely up to you. Then you really can't sanction the notary for that. And so I can see where maybe that line got crossed. I'd like to give you guys a quiz. We'll just take this home, and what we'll do is on Thursday night, briefly we'll cover the quiz, or maybe we'll shoot them the answers before Thursday.
Let's do it Thursday.
We'll do it Thursday before.
Yeah.
We'll do Thursday before. We'll do the quiz Thursday before, and then we'll roll into Chapter 8. The material starts getting a little better.
I know, I like that.
All right, it gets more interesting
Grab one on your way out.
as we start to get into some more legal type stuff. So Chapter 8 picks up with the more subjective, more interesting material.